Here. Stewart.
Here.
Calling for approval for the agenda for this meeting. And I'm going to amend. Second.
We're gonna put that under new business.
Under approval of the agenda for this meeting.
Yeah, but are you gonna put your,
Amendment.
under A, under new business?
I'm going to put it under A.
Order of amend, unfinished business? That was me by A.
Right here.
Are you gonna put it under new business?
I'm looking at a different agenda.
Okay, I'm saying. Under new business?
Under new business.
Okay, all right, so moved.
Second? Second. All in favor?
Aye.
All right. Yeah, we should just be looking at the same agenda. All right. Approval of the minutes of the meeting of May 23rd. This chair to reflect on this.
I just saw one error. It says Vice Chair Stewart. They can call, so Stewart should probably be front right. And call should be placed in after your name. Right on the very first.
Yeah, but under what, election of officers, is that what you're looking? Oh,
Right there.
I'm sorry,
Call the
Thank you.
meeting to order.
okay,
Just
gotcha.
a little typo.
Okay, good.
So moved, accept the minutes of, May 23rd, with, as amended.
Second.
All in favor?
Aye.
As chair, I know that the court reporter is present to transcribe all verbal comments and statements for this meeting. This is not a normal procedure for the taking of minutes at board meetings. As a result, the chair would entertain motion and second to accept the court reporter's record of these proceedings and supplement to and as a part of the regular minutes of the meeting, subject to the review and approval of this board at its next meeting.
So,
Second.
All in favor?
Aye.
At this time, the board will hear public comments on any matter not related to the case of the Saugatuck Coastal Alliance versus Township and North Shores of Saugatuck LLC, pending in Allegan County Circuit Court case number 17-58936-AA and 18-59598-AA. With any such public comments? Hearing any? We'll move to new business. The only new business to address is I thought it was important since at this point, maybe unusually, but I thought it would be important for you to know who we are, just briefly in terms of our profession, before, after, during, whatever, just so you know who's sitting in judgment. And so even though that's an unusual move, I'd like to call on my fellow board members. Rex, would you please tell us your business?
I'm the owner of Wolverine Trenching Service in Fenville. My business primarily specializes in demolition, construction, drainage, and other associated excavating contracting.
Thanks, Rex. Patrick?
I guess through my career, I founded a number of specialty chemical businesses. Most current one in the last 30 years is sustainable commerce, environmental equipment. chemicals.
Thank you. Denise?
I'm retired. I was an assistant professor at Central Michigan University, in our athletic training program. And, I retired, in April of 2020 and moved down here in, the fall of 2020.
Thank you.
My name is Tammy Kerr. I graduated in engineering, college, mechanical, worked for a couple builders designing houses. I have an interior design degree also, and I sell real estate. I've been selling real estate for 4 years now.
Can you all hear? Okay. And I'm Catherine. I've been practicing attorney and continue for the last 27 years. So that gives you a little bit of flavor of who we are. Now, we have on unfinished business, the order of remand. Copies are from Judge Kangas. We have them in front of us, the order of remand. Is it in the packet? Yeah, right here.
On page 4, red number 4.
Okay, and I expect them to read this order of remand.
Jim, do you want us to read the,
Yes, I think that,
Put it on the record.
yes,
Order after hearing regarding appellant's motion to strike. The court conducted a hearing on April 24th, 2023 regarding the appellant's motion to strike, in which all parties were in attendance. In lieu of issuing a decision regarding appellant's motion to strike, the court hereby remands these cases to the Saugatuck Township Zoning Board of Appeals pursuant to MCL 125.3606. Runs 2 and the Michigan Supreme Court's decision in Saugatuck Dunes Coastal Alliance v. Saugatuck Township 509 Mich 561 runs 2022. This court, for reasons stated on the record, determines that the record is inadequate to make the review required by MCL 125.3605 and MCL 125.3606 runs 1. And finds that additional material evidence exists with good reason was not presented to the ZBA. The ZBA is instructed to decide if the Saugatuck Dunes Coastal Alliance has standing to appeal the decision of the Planning Commission based upon the test announced in the above cited Supreme Court decision. The ZBA is also instructed to consider the evidence submitted to it previously and also any additional material evidence that with good reason was not presented previously for purposes of analyzing standing and to follow the procedures outlined in MCL 125.3606 parens 2. Motion on that?
no, that's just a statement to read it, and then the next one is the order of Judge Jacobian.
it's on page 6.
Page 6. Order on motion for clarification, which was the most recent order. Saugatuck Township having filed a motion for clarification and or relief from the order of Judge Kangas dated April 27th, 2023. Plaintiff, Saugatuck Dunes Coastal Alliance and defendant, North Shores of Saugatuck, having responded to all arguments having occurred on December 11th, 2023, the court being advised in the premises. It is hereby ordered that Saugatuck Township's motion for clarification is granted in part as it relates to clarification of the April 27th, 2023 order and denied in part as it relates to relief from the order of Judge Kangas dated April 27th, 2023. It is further ordered that the previous ruling of this court by Judge Kangas on April 27th, 2023 is continued. Clarified to the extent that the Zoning Board of Appeals shall be permitted to consider as additional material evidence pursuant to MCL 125.3605 and 125.3606. Such documents submitted by the parties as of April 27th, 2023 for purposes of determining whether plaintiff Saugatuck Dunes Coastal Alliance is a party agreed pursuant to Saugatuck Dunes Coastal Alliance v. Saugatuck Township 509 Mich 561 parens 2022. The affirmation additional material evidence is defined as documents including those offered by North Shores, which plaintiff Saugatuck Dunes Coastal Alliance sought to strike, as well as additional reports authored regarding the impact of the project on the dunes area and on its members of the Coastal Alliance issued following the zoning board's decision and submitted by Attorney Scott Howard, all of which were referenced by Judge Kangas at the April 24th, 2024 hearing, 23 hearing, excuse me. Materials submitted by any party to a Saugatuck Township Zoning Board of Appeals after April 24th, 2023 may be considered only as permitted by MCL 125.3605 and 125.3606 and may be given whatever weight the Zoning Board of Appeals considers appropriate in making their determination pursuant to Saugatuck Dunes Coastal Alliance V's Saugatuck Township 509 Mich 561 parens 2022.
Now just move on. You don't need to, there's no motion or anything. Just move on to the public comment limitations.
All right, limitation on public comments. Comments by council will be limited to 20 minutes by mutual agreement for each party. Correct.
It's by agreement, the
By
parties,
agreement, the parties agree to 20 minutes.
Oh,
and the board chair has the right to accept or reject that agreement. But 20 minutes. seems to be
Agreement between
reasonable.
the parties, of course, I accept.
All right. And with regard to the public, individual publics, what is your ruling? How many minutes do they get?
To the public, the 3 minutes is normally permitted in our meetings,
Oh,
is permitted. It's 20 minutes. So we'll open the public hearing. And which council would like to start? Howard?
Thank you, Madam Chair, and members of the zoning board of appeals. It's been a while, and I appreciate seeing all of you again to discuss this matter. And I want to touch on a few different items. The first of which, though, is I think an important issue that has come up recently and has been discussed in general in the community, but also I think has potential specific application to this board's decision. And that is, we believe that it's appropriate for the ZBA to address the status of the permits at issue. And that is because there's two reasons for that. One is your zoning ordinance sets up a system and a series of regulations that says projects, once they're approved, have to move forward. And if they're not moving forward, somebody can come and talk to you and seek an extension for the deadline and give a reason for the delay. But if they don't, the project is supposed to move forward in a timely fashion in six months under the terms of the zoning ordinance. In this case is especially unique because number one, there was never a request to extend this permit under the terms of the zoning ordinance. And number two, in the interim, you've had a situation where the applicant reapplied for their permits from the state of Michigan and the federal government. That application was denied. So we're in a situation where, and they filed a contested case appeal of that decision, but we're in a position where one of the critical elements and one of the key requirements of the permit hasn't been met and can't be met at this point. So as a preliminary matter, we think that it would be appropriate for the zoning board of appeals to rule that in effect, this particular decision under the old permit under the old permit and under the old approvals by the state that have since in effect gone away, it makes this appeal potentially moot by this body or to be heard by this body. And really, the thing to do would be ultimately to reapply with the new parameters for the project, new design provisions, et cetera, that have been submitted to the state of Michigan and Army Corps, rather than seek a continuance of an approval based on the old permits and the old information. So we wanted to bring that to your attention and suggest that you would be authorized to make a determination that, in fact, it's a moot at this point and really ought to be only considered if and when the appropriate permits are received from the state of Michigan and the federal government. Item number 2 is that I want to talk about is sort of a reminder of sort of the big picture of why you have your binders in front of you and what Judge Jacobiak said in his opinion of clarification. First, we've provided you on our side. We've provided you with our binders and sort of an outline and explanation of why all the documents that you've been presented are there. And one of the, I think the critical topic for today, one of the critical topics for today is what to do with the evidence that came to the ZBA in the first place, what to do with the evidence that's covered by Judge Jacobiak's clarification, with Judge Kangas's ruling, and then what do we do with the last remaining documents, and how are we to look at those and consider those? So the sort of what I would say the 30,000-foot view of Judge Jacobiak's ruling is that you have information that that went to that was submitted during the original ZBA proceedings, and that's information sort of automatically in. And from the perspective of our information that we provided you in our table of contents for your binder, that's the stuff in the bluish, purplish. I was debating with my wife whether or not the color is blue or purple, and we're going up with bluish purple. Those are the documents that are highlighted in that color. Those are the documents that were presented with the original ZBA actions and are items that the judge and courts have said are clearly something that you need to review. The next sort of series of materials are items that were attached to the various pleadings, documents that were attached to the various pleadings in the case after the original zoning board of appeals hearing and were presented to Judge Kangas and ultimately to Judge Jacobiak as well. Those documents are ones that Judge Jacobiak's ruling makes clear. Those are items that are to be considered by the ZBA in your determination. For purposes of our documents, that is tab 10, 11, 12, 14, 15, 16, 17, and 18. Again, tabs 10, the Kendall initial opinion, that was an exhibit to the motion to strike. Tab 11, Kendall supplement exhibit to the motion to the Coastal Alliance motion to strike. Tab 12, Kendall and Hyman report, also an exhibit to the motion to strike. Tab 14, affidavit of Don Schuman, exhibit to the brief on remand. Tab 15, affidavit of Lana Pollock, exhibit to the brief on remand. Tab 16, the affidavit of Nick Wallace, exhibit to the brief on remand. Tab 17, affidavit of David Swan, also exhibit to the brief on remand. And tab 18, the USAC, Army Corps of Engineers memorandum of record and enclosures. Again, and that was an exhibit to the Coastal Alliance motion to strike. All those documents, we listed those out in the letter that we sent to this board, so that you have those in writing and have extra copies of that letter in case anybody did not receive it. But we've tried to outline that all for you ahead of time, just so that we can be clear about what we think are sort of the bright line documents that are to be considered by this board. So for our binder, again, you have that purplish blue colored documents that go through tabs 1 through tab 1 through 4. And yeah, it's a little bit, it's the last two are all pertain to, or last 3 documents pertain to tab number 4, but there's a total of 4 tabs, 4 sets of documents there that are for your consideration. And then the others that I just read, again, as Judge Saugatuck said in his opinion, you are to consider those. So what's the last category? The last category is our documents that Judge Saugatuck said you all are the deciders on these. You all are the ones who make the decision on whether it's appropriate for you to consider these documents or not. And the standard for determining whether or not those documents are appropriate are the standards that we discussed way back last October, and that is those documents need to be material, and there needs to be good cause for why they were submitted the first time around. And in general, I want to talk about the remaining documents that we have picked out and submitted to you that are also in the table of contents and also in the binder that we've given you. And the documents fall into the category that I would call sort of support and rebuttal. Now, the support is for the Coastal Alliance's standing in this matter. And the rebuttal would be to items that were raised by North Shores to suggest that we don't have a factual basis to have standing in this case. And because it's been a long time, I just want to remind everybody that this idea of standing is sort of the gatekeeping function. It's to make sure that the right people are at the table when there's a dispute. It's to make sure that the people who are at the table when there's a dispute have some sort of interest in what's going on in the particular project, and they're going to suffer those special damages that we talked about last time around back in October. It's really important to remember that one of the key starting points is looking at that Supreme Court opinion that we received a while back ago in this particular case. And it's important to start there for a couple of reasons. One of which is the Supreme Court sort of announces to you the standard under which you're to take a look at those documents and determine whether or not they're material and whether or not there's good cause. And the standard is that for purposes of establishing standing, you have to show special damages. That includes some sort of harm that you're going to suffer. In the case of the Coastal Alliance, the membership is going to suffer, or any particular member. Under the law, you need at least one member that meets that test. And then you have representational standing for that member or other members who all again have standing. But the test is a gatekeeping function. It's not a you don't function as a jury. You don't have to decide whether or not one side or the other is absolutely correct. You don't have to determine whether Dr. Lee or North Shores and his hydrological analysis is better than Dr. Kendall's analysis. That's not your job to sort of sort through that stuff at this point. Your job is to determine whether or not there is some evidence to support those special damage concerns. So, for example, we've talked a bunch about interdunal wetlands and the uniqueness of the interdunal wetlands on this particular property that we're talking about. And you've heard from folks in the Coastal Alliance who say, I study these very interdimensional wetland systems. I recreate through and around and near these interdimensional wetland systems. And my use and enjoyment of that area, my study, my concern about these particular natural resources is going to be impacted by this particular project. So that's the special damage that has been alleged. There's a suggestion that our project is not going to harm those resources. There's been evidence presented to that effect and suggested to that effect. You then have evidence that says, no, wait a second, your projections are wrong, your hydrologic model is wrong, and based on your engineering plans, you're not going to be able to do what you've suggested you're going to do in order to try and protect these resources. They're going to be harmed as a result of this project. So at that point, I would say that's where you sort of say, okay, time out. Our role in this process is not to determine which one of those sides is 100% correct or which one's going to end up being correct after this particular project is done. But your role at this point is to say, is there some evidence to support these special damage concerns? And once you say, yeah, there's some evidence there, that's you've met the standing threshold. Now, someday there may be a contested case, there may be a determination by this ZBA, there may be a determination by the court where somebody has to go through and weigh the evidence and decide, is Dr. Lee more credible, is Dr. Kendall more credible? But that's not what your job is at this point. Your job is to say, is there some evidence to support these concerns? Likewise, is there some evidence, the neighboring property owners, the Bewley Wallaces have suggested to you that there are going to be a number of impacts to them and their property if this project is constructed.
5 minutes.
Thank you. Some of that has to do with, for example, the sand piled in the lay down area. Some of that has to do with noise and sight and visual impacts to them and their use of their property. Interestingly enough, courts following the Saugatuck decision have said those types of things have been enough in other cases, and we'll talk about that more at sort of the appropriate stage, but they've said those are the types of things that give you standing, that can give you standing. And so what are the documents that we've provided you to support that idea that North Shores has said, you know, the Bewleys really aren't going to suffer any harm, it's not a big deal. We've provided you with the documentation on the laydown area, we've provided you with photographs and evidence that help explain that impact. We provided you with Nick Wallace's affidavit, and we've also provided you with the Army Corps' determination of the likely impacts of this very project on certain specific areas that are identified in Army Corps documents. Again, there may be a dispute about which side is right. Is there going to be impacts as a result of the laydown area? Is there going to be visual and auditory impacts as explained by the U.S. Army Corps of Engineers? You don't have to determine, again, which side is correct. You determine whether or not there's some factual support, some scientific support for these suggestions or concerns about special damages. Finally, I'd point you all to some of the cultural concerns of the tribal interests in the Kalamazoo mouth and the sturgeon restoration plan. Something that has been an important concern of the Coastal Alliance, frankly, right from the start. And we provided you with affidavit information from Liz Bellini-Smith talking about that sturgeon restoration program that's so important to them. And also you have information through the Army Corps of Engineers documentation that talks to you about the cultural impacts that this particular project is going to have on those tribal nations and their interest in the river mouth. That again those are critical pieces of evidence for you to take a look at and say, you know, is there some evidence that these folks are going to be impacted and therefore suffer special damages? Absolutely there is. Absolutely there is. The most important thing I want to leave you with is that I think it's important from a procedural perspective that you all go through the documents that have been presented and give us a kind of the parties a yes or no on whether or not that those particular documents are relevant and important and are to be considered. But what we have done with our submission to you is trying to make it as organized as possible, as easy to review as possible, and as clear as possible as to what interest we're talking about and how those interests meet those standards that the court has talked about, especially the ones of materiality and good cause. There's a good reason. There's a couple of tables or columns right along the side that helps you answer those particular questions. North Shores has provided you with a lot of documents. A lot of documents.
1 minute.
But I respectfully suggest that most of those documents are not material to that question of whether or not there's some evidence to meet that, those special damage thresholds. And while you can obviously read through all the contested case testimony, for example, which is some of the documents they've submitted, it really doesn't pertain to this particular proceeding. And it really doesn't, while it may set up the initial challenge of whether or not there's some evidence in the record of some nature to, you know, refute the suggestion that they've come to you with. The reason for our documentation is to say, we have those special damages. And if you have any question about whether or not there's some evidence that those special damages are in existence, it's there in your light blue binder.
Time.
Okay, thank you very much. Happy to answer any questions either now or through the proceeding as you consider individual documents. It seems like it might be helpful for counsel to be able to give you advice on or explanation on any particular document, but obviously I leave that up to you as a body and to the chair.
Does anyone have any questions of Mr. Howard at this time?
Thank you very much.
So I'm standing right on top of Scott. Members of the CBA, it's good to see you again. It's been a while. Coastal Alliance appears to prefer if the standard was, if we make an allegation, we're in. Ignore the facts, ignore what the science and the evidence says. If we say we're going to be harmed, you accept that and let us challenge this development. And if you look at the ZBA decisions in the past, you look at the court decisions in the past, you will see they do exactly what I am talking about, is they look at the evidence. They don't just accept allegations at face value. First thing to talk about tonight is the court's order for clarification. And what I want to do is talk through that a little bit, because the court, while the court didn't answer every question and give absolute clarity, we have what we have, and we have to live with that. There are some documents, though, that the court did give us absolute clarity on. And I want to start with those that the court said do not come in. If you recall this slide from last night, this is a slide that is meant to illustrate how the Coastal Alliance was trying to add new claims, new people. Now, I understand the strategy, Because so far, every body, including this body twice and the court, the circuit courts, has said that those original 8 parties on the left side there don't cut it. They aren't aggrieved. There is no standing. So this concept of adding new parties, I get it. But the court has said, no, 5 years after an appeal is filed, you can't just say, oh, I'm aggrieved, and I'm aggrieved, and I'm aggrieved, and file these new affidavits and new statements on the record as if they were made back then. So the court, your counsel, on behalf of the township, asked for clarification, and here's what the court said. As it relates to the addition of new parties, the court does not find that that meets the standard. It would exceed the conditions that this court believes is proper to add additional parties, which would be the additional new 8 proposed parties. Now, this is an extremely important issue, so I want to make sure you understand exactly what the court was ruling. And to do that, it's helpful to look at what was in front of the court at the time, at the hearing where the judge made this statement. On the left there is the slide, the exact slide that I used with Judge Ankoviak. And on the left, it identifies the original 2017 claimants, 8 of them. And it identifies the new 2023 claimants that the Coastal Alliance is trying to slip in at the 11th hour here, including the over 1,500 members of the Native American tribe. So this was on the screen in front of the judge. And I explained, went through this all, how case law, talking about appeals, it's decided at the time the appeal is made, not afterwards. Oh yeah, forgot this. Oh yeah, this person's now aggrieved. Oh yeah, let's add this evidence in. And again, that same day is what the court said. So you have clear instructions from the court that the 8 new proposed parties, he called them parties, I call them claimants, they are not in. That would apply to affidavits filed. And in fact, today I would say to you, it applies to anybody that comes up and here verbally says to you, I'm a member of the Coastal Alliance, my name is such and such, and I've been aggrieved. New parties are not to be added. Now, when I'm done today, I'm going to give you something just so you don't have to keep all this stuff in memory, but an actual sheet that just has those 2 things on it so you can reference them, what was in front of the court and exactly what the court said. Let's move on to the documents that the court said are admissible. Here's how Chairman Justice read this. Here's how the court defined those additional material evidence documents. On the side of North Shores, those offered by North Shores, which the Coastal Alliance tried to strike. And the judge says, and as well as additional reports authored regarding the impacts, etc., all is referenced by Mr. Howard. Now, at the end of the court's opinion on it, he offered more guidance on this. As to North Shore, he says, the reports and exhibits that were submitted by North Shores, which led to the original motion to strike. So we had submitted some exhibits and some reports. They tried to strike them, and the judge said, that book of evidence is in. And as to the SDCA, he said, those reports that have been referenced by Mr. Howard in his brief. Here's Mr. Howard's brief. A report by Mr. Kendall, a report by Mr. Kendall, a report by Mr. Kendall, and we'll call a determination a report by the Army Corps of Engineers. Those are the documents that are in. Now, again, to try and keep this as straightforward for you as possible, when I'm done, I'm going to hand out a document that color codes things. Green is going to be on our side and on their side, documents that are already part of the record or documents that the court has said those are in. We'll use the stoplight colors. So yellow is going to be not admitted by the court, but left to the ZBA's discretion. Excuse me. Mr. Howard talked about those where you guys have some that you need to make some decisions on. But the third one is those that the court has already determined are inadmissible, and that's those new claims. So, for example, I'm gonna give you a handout that goes through our documents that are color coded like this, highlighted with green and yellow as far as what's in and what is still open for you to consider. And same thing for the Coastal Alliance. This is just a page from their submission. You'll see green where it was admitted, yellow, which is still open for you to determine, and red, which the court has said it doesn't come in. That's a new party, that's improper. So what should you do as to the yellow documents? That's up to you. You have to determine that they are material, and we'll talk about that in a little bit. You also have to determine that they were not presented for good reason. What is not presented for good reason? Does that just mean it was made afterwards? Ask your counsel about what for good reason means. In the end, your standard should be consistent and fair. If you're going to let in documents for the Coastal Alliance, it should, likewise, the documents for the North Shore should be under the same standard, and vice versa. We're not asking for, and I'm not advocating for all ours to be in and not theirs. The court has made certain things clear. You need to determine what the criteria is for the yellow. Now, regarding, what is material, I think this is part of it. I mean, the allegations that have been made are mind-boggling in this case. This is the approach the Coastal Alliance has taken, the epitome of the kitchen sink. It's easy to make an allegation. This development will destroy the interdunal wetlands in the area. Making an allegation is not enough. But why do we have so many documents? Because once they make an allegation, we've got to go get scientists to debunk it. And we've done that. That's why we have so many documents. I would suggest that you need to focus on what the Planning Commission approved. Do the alleged harms relate to that approval? Or is the opposition really to the fact that there's going to be anything built on this property? I want to focus and compare and contrast two township documents. So these are not our documents, these are your documents. The one on the left is a zoning map. And the one on the right is your township's attorney's memo talking about what was being sought for approval back in 2017. This property is zoned R2. Up in the corner, you can see it there. That means homes, community buildings, docks, piers are all permitted by right without coming to the Planning Commission for approval. And based on the dimensional requirements, this would allow up to 55 or so homes and 60 private boat slips. That's all by right. That's not approval by the Planning Commission. Now let's look at what the memo from your attorney said about what was being sought. Importantly, the developer is not seeking township approval of the boat basin. That's an Army Corps, that's an Eagle issue. Your attorney noted, like I just said, that this is R2 underlying zoning, and that allows for a lot of different types of development by right. And then the attorney summarized for the Planning Commission what was actually being asked of the Planning Commission. A few minor variances and an SAU to achieve a different configuration. But again, look at the numbers, 23 home sites, 33 slip private marina versus by right. Up to 55 homes or more, 60 private boat slips. What is being objected to here? Is the Coastal Alliance objecting to the configuration and saying that is what's going to cause harm? Or is the Coastal Alliance objecting to any development on this property whatsoever? In other words, that they don't like that it's zone R2. Look at it a different way. You've got a property that's not developed. Based on zoning, you could develop it with houses and boat slips and so forth in a certain configuration based on the regulations and density. Or the owner could seek Planning Commission approval to configure it differently See, it's not more houses, it's not more boats, it's just a different configuration. That's exactly what your ordinance says a PUD is for that flexibility. It's the same number, it's just a different layout. Again, does the Coastal Alliance objecting to the difference between those two developments? Or is the Coastal Alliance angry because the property is not being kept vacant? If the allegations and the complaints relate to the fact that there's going to be homes and boats on the property, period, that's not an objection to the planning commission approval. That's an objection to the underlying zoning. So that's where this goes to the materiality of the documents that you're considering. Do they come in because are they related to the zoning, or are they related to the difference between what's approved by right and what's approved with a minor variation? I think it's important to also keep in mind that this has been done before already. This is not the first time that this case has been decided, and nothing has changed that should bring about a different result. The Supreme Court, in describing its own ruling, uses words like "to the limited extent" and a modest clarification to the law. The court, of course, the Supreme Court doesn't decide the issue, they just set the right rule in place and then say, you know what, because we don't know what would have happened down below, we send it back and they look at it again under this rule that we proposed. We've talked about this before. This is a paragraph from the Olson case. And what the Supreme Court did is basically switch out this little phrase about who you're supposed to compare the Coastal Alliance members to. It used to be other property owners similarly situated. The Supreme Court said, no, don't compare it to that category of people. Compare them to others in the local community. Making it even simpler, summarizing the issue in this case quite simply, and of course, it's more complex than this, but have members of the Coastal Alliance suffered unique harm that is different from, it used to be other property owners similarly situated, and the Supreme Court switched that to others in the community. So the Supreme Court clarified the rule and this new measurement, this new standard. And because it's a different standard, the Supreme Court sent it back down to the lower courts. Now, whether the lower courts, and in fact, whether this body changes its mind, that would depend on how they applied the rule in the first place, wouldn't it? I mean, think about this. Think of like a geometry teacher going to his or her students and with a visual aid here saying, okay, when we measure, the right way to use a ruler is to measure with the inches side, not the centimeter side. Go back, look at your work, you can turn it in tomorrow. And everybody goes, they go home and they look at their work. You go back and you look at your work and you see you've already measured it using inches. So instead of spending the evening redoing your work like all your classmates, you're free playing with your friends, playing video games, whatever you do for fun.
5 minutes.
Because you already applied the proper rule. Don't you think it makes sense to do that before we spend too much time going through and reinventing the wheel, redeciding the case? So another handout I have for you is to do just that. In here is just a compilation of zoning board of appeals decisions and the circuit court decisions. And in here, just highlighted where this body compared it to the general public. The others in the local community, that's the rule. The next CBA decision, the general public. The state of Michigan, like state park, who enjoys it? The state of Michigan. Others in the local community, that's even bigger. That's the rule. The court. Community at large, community at large, community at large. That's the words the court used. That's the same rule. Now, this judge also used words like ludicrous and beyond reason and common sense to describe the allegations in this case. We'll let you guys decide whether you agree with that part or not. And the second judge, everyone in the area, community at large. I think they've already measured in inches. They've already applied it. Tonight's about the documents, right? Think through what the issue is. And I think you'll be able to pare down the documents that are relevant and material in this case. If you were to ask, what are the top 10 documents that we should look at? I'd say there's 3. The zoning map. Look at the zoning map. What is this property zone? R2. And what does that entitle us to do? It entitles us to build houses and docks, etc. Look at the Dickinson Wright attorney's memo. I think it's in our appendix, page 44. 17 is the first one, 44 is the second one. That describes, in a nutshell, what approval was being sought. So you have to ask yourself, what was that approval? That memo answers that question for you. Thirdly, take a look at the McKenna report, the independent planner that this township hired to review the project, and how that planning company saw this project. They said, this is awesome. You've looked at the property, you've evaluated where it makes sense to build, where you can maximize profit in small areas so that overall there's like 50 houses on 300 acres. That is a conservation-based approach. Those are 3 documents that all come from you guys, the township. And those are 3 documents. The third one just gives you an assurance that this is a conservation-based plan. The second 2 show you that the decision actually being appealed is not whether this stays as a meadow or not, or an open field, or an uninhabited forest.
1 minute.
But that the decision really was a different configuration. Houses and boats in one way, or houses and boats in another way. That's the decision. That's not what Coastal Alliance is objecting to. They're objecting to any development at all. I am going to grab those handouts and give them to you. And while I do, are there any questions from you guys?
Any questions? I have one.
Yeah.
In my reading, and this might have been applied to something you said in a court dealing, where you said that the documents that should be admitted, that the court wants documents that were presented to the court that were not presented to the ZBA. Do you recall anything? That there were certain documents presented to the court for that hearing that were not previously presented to ZBA.
Yes, so. Back there, because I don't have the documents here, what they say, as you might
I
imagine.
should have brought the document.
So we're talking about the court's order and its verbal opinion, right? So to me, this is the clearest statement that we have from the court. As far as what documents are to be considered. In other words, telling you as the ZBA that there are certain things that should be considered. Is that what you're kind of thinking of?
Yeah, it was a quote, and I don't have it in front of me. I'm gonna table it.
Okay, okay. Any other questions?
Remember that? You remember reading that? I thought that's. That was what we were collecting.
That's what you said.
I mean, this is clear. The court's instructions here apply to certain documents. And there was exhibits attached to our brief that were presented to the court. And that's what he's saying are in reports and exhibits that were submitted by North Shore. Are you looking for the list of those? Is that what you're?
No, I'm not.
Okay.
Thank you, that clarifies.
Public comment?
Public comment. Anyone wish to speak?
Okay, if there's no one wishing to speak, then you can move to close the public comment. Move to close the public hearing portion of the meeting.
So moved.
Second,
Second.
all in favor?
Aye.
Motion passes unanimously. Public portion of the meeting is.
So the panel is now confronted with several options that you have. And I'm only doing this to give you what your options are. You can now debate in public here what it is that you, as far as these documents are concerned, want to consider in your ultimate determination of whether the SDCA has standing in these proceedings, to argue about what the planning commission decisions that were made in 2017, period. You can adjourn and decide that you want to review the material further. That has been submitted here today. That's up to you. And try to give us an idea of when the next meeting might be so that the public discussion of what should come in and what should come out would happen at that meeting. You can decide everything tonight. It's completely up to you. I have prepared options, motions that give you options that you might want to look at. I can certainly give copies to council. You may want time because the motions are rather lengthy in nature. And you may want to make changes to them here in the process of the meeting. So those are your options to proceed going forward. If you want to discuss it, please discuss it among yourselves, what you want to do, because it's I hate to say this, but it's a sports term. The ball is in your court, and you guys got the paddle, and
Can I have substitution?
yeah. Now you're wondering about why I'm here. Yeah. All right, but those are your options as I see it. Council, are you SPCA council? Carl, are you agreeable that Scott and Carl, are you agreeable that those are the options the board has at this point?
Yeah, I think so. I mean, I have some suggestions for you. You probably heard those already.
So it's up to you guys what you want to do, and you can talk among yourselves freely. It's on part of the record. Remember, you can't, everything that you say is going to be part of the record of this proceeding. So you need to be aware of that, so it's not, you're not finding out what kind of coffee the other person likes in the morning, things like that. You need to stay on task about these documents, what you want to do about them. You want more time to read about them. Somebody may not have had a chance to read everything. Well, then they need to talk and say, I haven't had a chance to read everything, and I'm concerned that I'm not informed enough. You have the right to ask questions of the council to clarify your concerns. It's completely up to you what you wish to do.
My understanding from our earlier discussion was that we were just to look at documents, and we were going to come in today and just talk about which documents we believe should be added to the record. And then after that, we would be, a future would be determine whether those documents, if we all agree with that, then to, again, visit those documents and whether they are material to standing. So that's how I prepared for today. And as I looked at these documents, I only have a few that I felt that were not provided and originally at the ZBA meeting that we should consider for further discussion in regards to standing at a later date. So I only have a few that I really felt that that wasn't presented initially that we should consider.
I agree with what you said. Hopefully people have a list. If you have a couple, you can tell us what they are, and then we can go back and review them or discuss them.
I agree. So I'll be happy to share with you what I've done, and then we can go from there. Do you want to start?
I'd be beautiful.
Thank you. First of all, I thought the affidavit for Nick Wallace, even though I understand that from council that should not be brought in, but if we look at prior minutes, Nick Wallace has been involved in this litigation from day one. He was 17. So if I look at a minutes of September 11th, 2023, it is clear, and it was due to our corporate reporter, that he was 17 at the time. He did come in, he has spoken and has been involved with this from day one. However, he was not able to do an affidavit. So then therefore, he's not a new individual, new climate person involved with this, is that now we have a written affidavit. So I think we should consider his affidavit in regards to what is material. I also looked at the USACE memorandum for record and enclosures. I would agree that we should look at that particular document. It is dated November 15th, 2022. It was by Mr. Charles M. Simon, and not only his document, but all the enclosures. So that's from the Department of the Army Corps of Engineers that was presented. I think we should look at that particular document. I'm also interested in of the August 29th, 2023 document from the North Shore lawyer that referenced a public hearing that was comments from received by the Michigan Department of Environment, Great Lakes and Engineering, and they are responding to that particular public comments, but I don't have the public comments in front of me, so I don't know, I don't understand what the public comments were that he's responding to. So I don't know if there's something that we can get, but that is an August 29th, 2023 document. So those are the only documents that I thought that we didn't already, that the ZBA may not have seen, and for good reason, that they should be looked at again. So those are the only ones I know.
Thank you. Rex?
I don't have any documents to present.
I have a few, one of the ones the same that you asked for. All of these are related to the technical arguments concerning the construction and operation of the lagoon as they affect the water table of the protected dunes, endangered species, and the general well-being of the dunes and the river. So I just focused on the technical reports on the operation and the construction of the lagoon. And there are, in this Gabriel letter that you referred to, there's a section on that, and that's why I think we should include that.
Can you describe that a little bit more for the record? Sure.
This on page 6 under the section wetlands.
Is there a title for the document that you're reading?
It's a response to Eagle correspondence dated August 10th, 2023, application number HPF-7 AAA-RGC 7Q.
Okay.
And the session is discussing the
There's a list.
the water table.
All right,
The water table with technical issues on
all
water.
right.
It's a, talk about a lot of things, but that's just the wetlands portion that I was referring to. The other document is, a letter on March 2023. Because I don't know when it's submitted, I gather it was not submitted by the April 23 date. And it goes into deep discussion of
Who's the letter from, Patrick?
I'm sorry, the letter from Anthony Kendall.
Yeah.
Yeah, to David Swan. And it discusses in great detail of the various construction and operation. And also, we have a document from Michigan State University. So,
You can do a date and an author, but
yep, for July 13th, 2023. Department of Plant Biology. When we're available.
Is that the July 13th,
Yeah.
2023?
Yeah.
Yep. To John
John Boy.
Fahey, okay.
And I don't have it off, but I'm sure. And once again, that's discussions of the construction, maintenance and operation. of the unit. So it's those three documents that I'd like to.
can you describe what you're suggesting to add it to, just so the record's clear? You're adding it to the, and this is the impression that I'm getting, and I don't want to put thoughts in your mind, to the record that already existed from the earlier ZBA meetings in 2017 and 18. These are the documents you want to add to those records that are already in process, that already were.
These are documents that were not dictated by the court to be considered.
Oh, all right.
And documents that were after April 23rd, 2023.
And then we are to look at those documents as to whether, as to whether they are material to standing.
Yeah.
So we're identifying additional documents
Okay,
to add, possibly add. And then our next meeting is to determine, as we looked at those documents, if we all agree that we should consider those documents, do they add to a material to standing? Did I say that right?
At the next meeting.
At the next meeting, that's what I understood that we were going to
Yeah,
do.
do we want to do it at the next meeting, or do we want to consider them now?
I'm not prepared to consider them now.
Well, I think that we should,
Do them at the-
that was the thought that we were going to look at consider other documents.
Yeah.
And then we would have to go back as a board, and say, yes, I would agree, because we see that they added to standing. Am I saying that right?
No, yeah, I agree.
Gentlemen, am I saying that right?
yeah, the documents that you,
Identify.
identify need to pass two standards.
Correct.
One, are they material to the determination that you're being asked to make relative to the standing, which is the person/party aggrieved?
Correct.
It's statutory language, the standing of SDCA. And second test is there good reason that they were not presented to this body
back in 2018 by April 9, 2018.
Right.
So those are the two standards that you need to meet in making your determination of what you should consider, what you want to consider.
Right, so the therefore is we have to go back and look at those documents again and determine those two
on
things.
those two standards that are in, those two standards are stated very clearly in the statute MCL 125.3606 sub 2, if I'm not mistaken.
Right.
I apologize, I didn't read my whole, which I should have. It started out with, I'm comfortable with the evidence is material for the purchase to determine the likely special damages and therefore confident in determining status. That's something we have to determine in the next week. And, so,
Yeah, do you have any other,
no, just those three.
Tammy?
I have none.
And I have none.
Now, what I would ask, just again, because we have to be concerned about the record, everything that we do here is going to be looked at by many, many people, okay? And we want to make sure that what you're asking them to look at is clearly identified. So I would ask that each of you that have suggested additional documents, that you provide them to Cindy immediately after the meeting, and Cindy will make copies of those very documents so that everyone or whoever has them handy, we can then identify them, and it's clear that we circulated among you for determination at the following meeting.
Don't we already have them?
We do.
We do, so you want a list so that then we
Because-
go back and look,
Well, everybody, we just want to be clear on what's being identified for us.
The descriptions that you gave are great, but we don't have all the documents in front of us.
And truthfully, it's very hard for people to run through the focus stuff.
It's hard to, right, exactly.
We took
So-
them out of my books.
There's only a handful of them.
There's only a handful, so it'd be
So
easier.
we'll have easier access.
I think these are it.
Yeah.
I took
Okay.
them out. If you,
I have it.
if somebody wants to double check.
So that, I think that'll help us, make sure that the record is very clear.
If I have to reread them, I don't want to find them.
Okay. So. Is that,
So I understand, make sure I understand. These are gonna be the only documents in the third category of discretion that the boards can consider accepting. Is that everybody else understanding?
that's my understanding.
That's my understanding.
Yes,
I'd like to put that in the form of a motion,
so be it, Rex, go ahead.
that these documents that Kevin has in her hand is presented this evening for this further discussion are the only documents that we're gonna look at in this case going forward, with the exception of the already accepted documents accordingly. That sound about right?
well,
So,
There's a motion.
I know, could you repeat that motion, please?
Maybe. I want to say that I believe that we should allow these documents, the documents presented by Patrick, and not by Denise, as the only documents we'll review outside of the previously reviewed document that we have under control.
So we have a motion ready to accept,
Here, Kenny.
I would second that motion.
to accept identified documents created after April 9, 2018 for consideration. SBCA standing.
Correct. Correct. So I read this proposed motion into record, or are we comfortable?
well, there's one thing that's come to my mind, and let me present it for your consideration. I'm not trying to give advice here. I'm concerned about the record, all right, so that the record is absolutely clear. When Rex first talked about this, he said, let's have these documents that Denise and Patrick mentioned, and the ones that the judge said we were to review. Now, I don't know what those documents are either, so let's clarify that. And do you want to review the materials that the prior board UBAs reviewed in 2017 and 2018?
We have that information automatically by accepting the court's. I think we have that information included by accepting the court's directives.
That's what you should, in your motion, you need to be very precise. Because again, many people way beyond this room up in Lansing will be looking at this someday. And we have to act like that's gonna happen, maybe it won't. But if it does, we wanna make sure that what you're telling us is precisely what you want to look at.
What I think,
Should we just quote?
what was, I intended was that the documents discussed here tonight and listed by the parties involved would be, I think.
By Patrick and Denise.
By Patrick and Denise would be the only documents we consider that were submitted after the April 23, April 24. The judge said we could consider documents after April 24, right? 24. April 23.
April of 23 and April of 24.
April 24.
and 2023.
Yes.
And
Oh,
the
I see.
documents before that have been directed by the court.
Right, prior to those documents, prior to that, we're discussing basically the documents after that. And I'm suggesting that we'll only handle these 5 documents that were discussed here this evening.
All right, so let me see if I've got this, if I've got your motion in mind here, if I'm correct. There was a hearing issued, an order issued by Judge Kingus on April 27th, 2023, that ordered specific documents, or that mentioned specific documents. Judge Ankoviak in January, strike that in, I think it was
December.
sometime late in the fall of 2023, we filed a motion to clarify. We had a hearing, the transcript of which NSS talked about this evening. The judge issued an order on that. So your motion, Rex, is to add to whatever the judges told us you had to review in either the motion for clarification or Judge Kangus's order. And the materials that were present and reviewed by this body back in 2017 and 2018 hearings.
Correct.
So that's my concern, those documents are included in the motion that we will be able to.
Yes, I'm not trying to tell you what to do. I was trying to clarify it.
That's what I'm trying to say.
Okay. So we need to get that in a formal motion. And I had prepared a form motion that,
So it'd be both of these motions?
yeah, you might want to do
The
both of the
motion
motions.
for 2017 and 2018 records on appeal from standard and to accept identified documents.
Yes.
There you go. There you go. In other words, what I'm trying to say is that at the next meeting, somebody can't come in there with another batch of documents
Right.
and say, hey, I was looking up this stuff. I found this. Now we want to get into that. I think we're going to stop it right here with what's been proposed this evening. We discussed this in the previous meeting. We decided to bring our concerns here tonight, and we've done that. And I think that it's time that we rule or decide on what the concerns are and get moving forward. And that's the purpose of the motion, and however I have to put that together, that's what we got to do.
Well, here's what I prepared, and I
Yes.
sent copies to the chairperson because I was preparing these today, trying to get the latest and the greatest information, which just came in yesterday afternoon. No disparagement meant. I prepared a motion to accept for consideration of standing the 2017 and 18 records on appeal to determine the standing issue. So that's part one kind of your motion.
Yes.
Okay. So you can use that motion. Now, I also prepared a motion. Again, trying to, I've got to go to this version just a moment. Yes, I prepared a motion entitled Motion to Accept Identified Documents Created after April 9, 2018, which was the last meeting on the issue of standing held by this body in CBA in April 9, 2018, for consideration of SDCA standing. So then at the end of that motion, there's a place, put a list of the documents that you want to consider. Now, is that helpful?
Is that match?
No, because you have to fill in the blanks.
No.
Oh.
Does that match the orders of the 2 court hearings?
It
By
can-
that date, I don't think that's.
Oh, right. Well, remember, this first one said the first motion that I prepared, and again, this is my trying to anticipate what you all were going to consider. I'm not trying to tell you what to consider. But first of all, you have to determine whether you're going to look at the stuff, the old stuff from April 9, 2018 backwards. That's a given, okay? But I had to put it in a motion because when they're looking at this, they're not going to know it's a given until you motion it and say it. So that's the first motion. Then the second motion is, what else are you going to consider beyond that? And that's up to you, and you have to fill in the blanks. If you want to consider what the judges told you, then put it down.
No, I think that's right, except that my question was, in the Antoinette ruling, he said after April 24th, 2023.
Right.
That's the date we ought to use?
If you want to, you can use that, but the
Earlier date.
the earlier date's a given. The other stuff after the earlier date is not a given, and you have to identify exactly what it is that you want to consider.
So
Does that make sense?
which date should we use on your motion for the additional non-dictated?
Moment.
Well, this is March.
March
This is
2023.
March. So
Yeah.
it's just anything after
After
April 2019.
But his motion, so his motion doesn't, what's that, anything applies? But whatever gets it all. Whatever gets it all.
All right. So again, I'm only trying to keep the record clear so that the motion is properly recorded. We have the records that existed, but the given records, we'll say April 9, 2018 prior. Then there's this order that Judge Kangas issued on, that's dated April 27, 2000, just so we're very precise, April 27, 2023. He mentions that there are certain records that were brought up at the time of the motion to strike that preceded the April 27th order. You wish to have those listed, then you need to put that in this list of extra documents to be considered. Because I started in my motion, I cut it off at April 9, 2018. If you want to consider things after April 9, 2018, you have to list them specifically. So those I would put, if I were Rex, I'd say the records mentioned in the Judge Kangas's order of April 27, 2018. That's one item. Then the next item would be whatever you want to put in.
So anything that's on there will be.
Anything on there is in addition to the records from the 2017 and 2018 ZBA meetings. And I'm not trying to tell you what to do. I'm just trying to clarify it for the record because it's extraordinarily confusing. Good.
Who's on first?
See, we have April of 2000 18 and then April of 2023. We have to be very precise. It gets confusing.
No.
I did this rather quickly, but I want to make sure that the concurrence on these, the new information that we want to consider, and if you could kind of double check this with me, because
Well, on these, first of all, we should determine whether or not these 5 documents fit as adequate.
Yeah, that's what I was concerned about.
What is the date of these documents, we received them, and, some consideration. So I guess first thing I wanna know is that your way,
They are, well, right.
I don't know the answer to, I can't tell you, I don't wanna, I just,
if we want something fairly precise, we should know the date of these documents.
exactly right,
Submit this to us,
the most
so that we
recent,
make sure that we're not stepping on our own foot here.
precisely put.
So we need to find the date of these documents.
the most recent date that's been recommended is September 25th, 2023. And that's the affidavit of Nick Wallace.
That's the latest.
That is the latest.
What's the
It's the latest. The earliest is a November 15th, 2022 Department of the Army to the State Historic Preservation.
That's the date, did you get it?
And what was the last date?
The last date was September 25th, 2023.
Well, I don't want to include all documents in that time frame. I want to include the 5 specific documents. that we're talking about.
Right.
Not all documents in that frame of time.
No. Do you want me to read that into the record what these documents? are?
Well,
Would that be helpful to you, or-
somebody's gotta make a motion, and you gotta figure out what you're gonna do. My suggestion is that you take the motion to accept the 2017 and 2018 records and get that passed.
Range. including the documents.
Correct, it does, but
Behavioral documents.
But what we're talking about now is first going in and accepting the 2017, 2018.
ZBA records.
CBA record.
And then we'll clear that deck, then you go to the next step.
No,
No. I just want to make a motion to accept the 2017 and 2018 records on appeal to determine standing.
Second.
all in favor?
Aye.
Aye, opposed? Passes unanimously. The second motion that we need. Rex,
I move that for consideration for the purposes of deciding this matter, that we consider 5 documents presented at this meeting specifically. We'll have to get the numbers and, or the listing of the authors and the dates, page numbers, I suppose. If I can have some help with that.
I'd be glad to help you with that. Specifically, November 15th, 2022, Department of the Army, letter to the State Historic Preservation Office. The letter on March 20th, 2023, from Anthony Kendall to David Swan. Trying to keep this. July 13th, 2023, a letter from Michigan State University in reference to objections to the proposed marina. August 29th, 2023, Department of Environment, that was sent from Mr. Gabriel. Sorry. Gabriel from the North Shores attorney. Let that be admitted. September 25th, 2023, the affidavit of Nick Wallace.
I move that those documents be considered. And that no other documents will be considered going forward.
That's the motion. Is there a second?
Second.
Well, clarification,
Yes.
so that, again, the record is clear. Are you also including in this universe of documents, Rex, what the judges required
Yes.
ordered? And those documents are really, we've been talking about the briefs, the motion to strike. And that's what Judge Kangas ruled on April 24th. So those you want to also include
Our previous
April
motion.
27, 2023, sorry.
Our previous motion was to accept those documents.
No, it was
We only covered.
April
Oh,
of
okay.
2018.
Yeah, okay,
Okay,
all right.
that's why this gets very confusing. So your motion would include the documents that the Judge Kangas, received and commented on in his order of April 27, 2023. That's my,
Yes.
and he ruled on
It
it.
just rolled on, yeah.
He did. Okay, so those are included, and that should be on your list, the way that this motion is established.
So we have the 5 documents listed, Catherine.
Yes.
And we have the addition of the documents approved by the judge on April
27,
23.
23, right,
Correct.
okay, now we've got a good explanation.
Okay, yeah. So moved.
Now,
Second.
go ahead, just to clarify, you're not saying that these are material and
No.
of good reason, okay, that's not an issue, that's gonna be next, okay.
These are only what we're going to.
Just didn't wanna have any concerns, okay?
With Rex's motion, Tammy seconded. All in favor of the motion? Does everybody understand the motion and the documents that we are including in this motion? All in favor?
Aye.
Any opposed? Motion carries unanimously.
Okay, now, what are you gonna do? You're gonna adjourn to another date? What are you gonna do?
I have a question as a point of reference for you, sir, Mr. Power. Why would you suppose that we would just drop all of this because the permits expired and so on? I mean, isn't that your partially your responsibility? Is that it?
I'm sorry.
Your opening statements were that we could consider just forget the whole thing based on the fact that the permits have expired. Why would you suggest that?
It's way though, what the zoning ordinance, that's the process. So. One ordinance tells you to do.
You don't think we've been moving forward? But they've been moving forward with this at all, that doesn't qualify as moving forward, what we've been going through here?
Respectfully, I don't, I think that the process of going forward is actually doing the project, not zoning board of appeals, you know.
So you would consider then that the permit process is more important than the zoning approval? So that,
No, I don't. I hope I didn't give you that impression. That I think that the permit process and the zoning approval are not co-equals. They can happen at the same time. They can happen one before the other, but I don't think either one of them they're two separate and independent processes. But they're also cross-referenced in your zoning ordinance in terms of required permits. So, for example, the approval for the North Shore project said you have to get your required Army Corps and, state and Army Corps permits. So it's a requirement of the ordinance. There's a cross-reference there, but they are, I'm not trying to suggest one necessarily trumps the other, but you definitely have to have as part of your zoning process, and your zoning ordinance requires those state permits and those federal permits to be in place before you start constructing a marina.
we're not talking about constructing it, right?
I
We're
would,
talking about, whether or not the Saugatuck Coastal Dunes Alliance has standing in this issue. So the two are unrelated, in my opinion. If they've been held up by you, and now you want to say they're held up, well, don't get them.
I think there's.
I don't get the argument.
Yeah, I don't either. I think there's a circular argument here.
Yeah,
I get permits to build something. And then the Corps of Engineers and Eagle doesn't rule for how many years? 6, 7? And all these legal proceedings go on, so I can't do construction. I don't understand the logic of that. It's a circular argument.
I think that the way that the zoning ordinance handles them is it says, come back to us and, make that request that there's some sort of extension. That's what the ordinance provides, and that's the remedy in case, in a situation where somebody feels like they're being held up. Come back and talk to us.
I think there's an implied extension existing here because of the matter of the court proceedings, that it's implied that this is extended until completion of this. So I don't agree with it.
Could we get an opinion of this before the next meeting? Legal opinion?
If you request one from us, we'll do that. If that's what you would like us to do,
I
sure.
don't think we can answer that. I think it's legal.
We'll give you
legal
our take
technicality.
on it, but,
It isn't a logical thing.
it really falls more, to be perfectly honest with you, it falls more in the category for Mr. Curcio, who is general counsel. I certainly would not want to, invade his area of expertise because he's the expert in the, zoning ordinance and its application. It was his correspondence that was involved in, his opinions were involved in the original determinations of the granting of the PUD and SAU permits. So it really falls into his bailiwick, so to speak. And you could move to have the chair request an opinion from him on this issue.
Do we have to respond to it?
Do we have to respond to
Do we
what?
have to respond to the question?
No,
No,
you're not.
you're not under any obligation, but if you're curious and you want to know, you have the right to ask for that.
I don't want to ask for that. I want them to explain to me why they bring it up. That's what I want.
That could be, that I think, he's explained better, he can, and
Yeah.
your position is no.
Yeah.
And in polling panel, we are in concurrence with you on that, and we do not wish to pursue that.
All right. So now what does the board wish to do? Does the board wish to,
My understanding is that our next scheduled meeting is that we're to come back and look at the documents and whether they are material to standing.
okay, then make a motion if that's what you want to do.
Is that what
To
we
the
decided?
next meeting.
Material and legal costs.
Yes. So therefore I move that at our next meeting, which is scheduled for July. Is it July? No, I thought we had one in
It
June.
was June.
Wait, I propose a couple of dates that we could use. And the first one where we can get a quorum that I can figure out, and all 5 of you here, would be June 27th at 4 o'clock. So that would be my
That's
proposal.
what we had discussed.
Okay.
And then we could reserve a couple of dates in July, just so we can, re-adjourn or
Continue.
without another
July.
delay. July is 11, 18, and 25.
Yes, 11th,
Yeah.
18th and 25.
Those dates, I was okay.
Okay.
Right,
Yes,
That's
but
what
I
I-
did consult with you to see when we would be available. If Denise, if you have a conflict, just let me know, but the.
No, we decided that at our
Yeah,
last
so
meeting.
last week.
I would entertain a motion as to the date of our next meeting and as to what our proposal is that we will discuss. Would anybody like to make that motion, Denise?
Sure. Moved that on June 27th, we are to review the documents and in regards to, I have to make sure I say this right. Are they material to standing and had good reason not to present prior
technical.
through
terms.
2018, right?
Yes, good reason, yes.
Yes, good reason for 2018. That's my motion.
Second.
I would just specify the documents that have been identified.
Yes,
That we've
Yes.
identified on the record. are the ones that we will be reviewing.
And the one
That is-
from 27th.
And yes,
Okay,
This attached to.
there's a second to that motion? Yeah.
yes,
Okay,
Rick seconded. All in favor? Aye. Opposed? Motion carries. We can entertain a motion to adjourn.
So moved.
Second.
All in favor? We got through. Motion, meeting adjourned.
good.